Hi, everybody. This is Cliff Rosenthal. I'm a partner at WI Immigration. And with me is my esteemed colleague, Josune. And we're going to talk today about H-1B alternatives to the H-1B cap lottery. Let's go, Josune.
Thanks, Cliff. I know our colleagues spoke to y'all about this last week, but since there's so much ground to cover, we thought we'd add a little bit more. So getting straight to it, our colleagues spoke a bit about cap exempt, but Cliff, being the expert here, can you give us a bit more about that?
Yeah, so cap exempt is a category that does not go to the lottery. So that makes it very, very important to immigration strategies. So for instance, the main cap exempt organizations are going to be universities. There's also nonprofits. But these are not all nonprofits. Nonprofits, research and nonprofit government organizations. One of the major mistakes people make is they think all nonprofits are cap exempt, and you're way away when you're a nonprofit. But it's very limited. It's limited to nonprofit research and nonprofit organizations, government organizations. So those are kind of the main ones. But if you fall into that category, then then you open up your whole immigration process to go beyond the cap and the limitations of the cap. So those are kind of the main ones that we look at.
So when an employer is thinking about their current cap and employees or potential employees getting selected or not selected, if there's individuals not selected, they can potentially benefit by having a concurrent, H-1B with a cap exempt employer, correct?
So that's an important strategy as well. So the way the regulations work is even if you have 1 hour with a cap exempt organization, even 30 minutes technically, but whatever it is, some minuscule amount of cap exempt employment with a cap exempt organization, you can use the rest of the time. It could be almost full time with a non-cap exempt organization because you become cap exempt based on the cap exempt organization itself. And any other non-cap organizations will be included in that. So that's kind of a strategy that we see very often. If you work for a university, you've got part-time work at a university, then you can work full-time at a non-university as well.
But doesn't necessarily mean they're off the hook or shouldn't be included in future lotteries, right? Because what about going full-time to that employer?
Correct. So in addition, university work may not be full time; it may not be continuous. So if that ended, then your cap exemption for the non-cap exempt organization would end as well. So you have to be very careful. And sometimes it's not practical. Sometimes the university work or the cap exempt work, you don't want it to continue. You want to focus on the private industry work. So it's always a good idea to put that person in the lottery as well, because at that point you could always get off the university work, for example, and move to the cap subject employer full time.
Great. Now, what about going straight to the green card? Is that a viable strategy for the employer or employee?
So in many cases it is. It all really depends on that visa bulletin that everybody or many people are familiar with, and depends on backlogs and how quickly things can be done. So generally, if the person is not born in China or India where there are big backlogs to green cards, it's a very viable strategy depending where the person is in the process. So for instance, if the person is starting the OPT, it's a STEM field, and you've got almost 3 years to play with, then there's a very good chance, especially if it's an AB2 category, which is backlogged maybe about a year at the moment. There's a very big chance of getting through that whole process before you get through the OPT. So that would be one way to do it. And it's a very popular way to do it, especially for those that are not born in China and India. Unfortunately, if you're born in China and India, there are big backlogs, and the chances of getting through, even with a full 3 years of OPT in the EB2 category is very difficult. But there's the EB1 category, and even though they are backlogged, even for Chinese and Indian born, they tend to be much less backlogged, and there's definitely chances of getting through the process if you qualify. But certainly, those EB1s are the highest level of scrutiny, the toughest categories to get through. So you really have to make sure the person is really qualified for that.
Yeah, no, that's all great. And when we're talking about then, if we can't go straight to the green card, we're looking at maybe different types of non-immigrant visas. And a lot of times we get questions about J1s and how viable that would be. What do you think about J1s?
So J1s are good options if you meet the eligibility requirements. And one of them, just take a step back, perhaps. The J1s are exchange programs. So they're coming to the United States to learn something and then go back and teach that with your brethren, with your home country. So that's kind of the context of the J1 visa. So if you're coming for the J1, there are very different types of J1 categories. So if you're coming on the J1 to be, for instance, a research scholar, the kind of the expectation is that after you finish that program, that you would go back and you would go back to your home country. So what the government does is they slap on a home residency requirement of 2 years on many, many J1 cases. So you just have to be careful, because if you do go for that process, then you might have to go home for 2 years before you could get an H-1B, a green card, and other visas. But other than that, there are lots of categories of J1s, and many of them are extremely viable in these cases. So if your research J1 is important, is probably the one we see that's the most common. The only one I would say you should be a little bit careful is the J1 trainee, especially if you've had OPT, because the OPT, especially if STEM OPT stands for optional practical training. So you've had 3 years of training, and now you're going to go for another 18 months of training. So sometimes, those become a little bit more risky. How much training do you really need in this position?
Yeah. But I guess one good thing on our hands is that we could now do premium processing as a cheaper status. So.
Right. So that's an excellent point. So for J1s, either you have to go home to your home country and you go through multiple rounds, you go through interviews and et cetera. And this would take a long time. Change of status in the United States would take 6 months plus, but premium processing with a deep fee, you can get it done pretty soon.
All right. So let's say, for example, we have a potential employee. The employer really wants to keep them in, but they're not buying into the J1 because they're going to be subject to that 2-year home residency requirement. What are other options that, potential employee can look at to remain in the U.S., but not, subject themselves to that?
So, there's, what was discussed before. I'm not going to go into too much details, but there's the TN for Canadians and Mexicans, the E3 for Australians, the H-1B1 for Chileans, and for Singaporeans. So, those are kind of clear options. But if you're not one of those nationalities, you're looking at the O1. The O1 is alien of extraordinary ability, person of extraordinary ability. That's kind of one option. That's actually quite a good option at the moment for those in STEM fields. The government, under this administration, has made STEM retention of STEM talent one of its priorities. And one of the things that they look at is using the O1 when the H-1B cap is utilized. The person's not, has not been selected. That's one of the core ways that the government's trying to use the immigration process to keep these talents. It's kind of made that they're supposed to look, even though it's a person of extraordinary ability, it's a high standard. It's one of the immigration vehicles that it's supposed to be applied so that they can really keep STEM applicants in the United States. So if you're STEM, it's a very good option. There is also different types of trainee visas, H3 visas, which they can be difficult, but if a company really has a training program that is and that they want to bring somebody on those, that's something we can use as well. And then there are different options. Going back to school at the end of it, doesn't give you work authorization, but it does allow you a person to stay in the United States. There are some options. What's called curricular practical training is one type of another kind of work authorization that comes with going back to school, etc.
And if the individual ends up getting a master's in STEM, for example, that gets them maybe that much closer to being eligible for a national interest waiver. going into, the green card option thereafter. But
yeah, absolutely.
And so we also get a lot of questions from individuals when they're not selected if, switching to a B1, B2 will allow them to, either stay and conduct some type of business here or allow them some flexibility. What's kind of your stance on that B1, B2 change of status?
Yeah, that's a very good question, because what happens is, especially the B1 has a business component to it. You can either come to the United States for business, and I think many interpret that to be coming to the United States for employment. Business and employment in different contexts are considered synonymous with each other, but not in this case. So in terms of what strategies, if the person stays in the United States, it's, extending, is or changing status to B1, B2 to buy more time is questionable, somewhat questionable. The question is what they're really in the United States to do. Are they here for B1, B2 purposes? Are they? So that always comes up. If someone is abroad coming into the United States and they come in for business, I mean, really business is business meetings. I mean, that's really the crux of the B1 business. I'm coming here for business meetings. So even though it's called a business visa, coming to the United States for anything more than meetings, being paid in the United States would all be extremely limited. They would not be allowed on this visa. So, maybe if the person really is coming for meetings and it's short term, that might be a very short term option, but very, very limited.
Yeah. Well, I know we covered quite a bit, and also, mentioned a lot what our colleagues previously said last week. So hopefully this gives, employers and employees some, resources and some things to think about when strategizing next steps if not selected. But here's hoping that we will have a better selection rate, right? We did talk about the beneficiary-centric program that we have going into this year's lottery. We do have, USCIS confirming that they're going to check with petitioners if they think there's multiple entries for individuals with different passports. So to clarify that. So, here's hoping that everybody gets selected, but if not, you have the tools to strategize correctly.